Number 1 on the dispositive motion calendar is Hupy versus Lewis County, 17-26-55834. This matter is before the court for the merits hearing related to a public records lawsuit that was filed by Mr. Hupy. Mr. Thomas is present on behalf of plaintiff in this matter. Mr. Eisenberg is present on behalf of defendant Lewis County. I reviewed the materials that have been submitted in this matter, and I am prepared to hear argument. Mr. Thomas?
Thank you, Your Honor. A Public Records Act violation occurred. Let me go over the facts in order to explain that, because I think this is pretty straightforward. Mr. Hupy made a public records request in December of 2015. Lewis County responded fairly quick, Lewis County, the former Lewis County Chief Civil Deputy Prosecuting Attorney, Glenn Carter, responded fairly quickly within the statutory time frame. But they didn't identify any documents that were responsive to Mr. Hupy's request.
And they just said, they gave him an answer to, I guess, they said the law library no longer existed and hadn't during that time period, that Superior Court now administered it, and that they then said the answer is, these are now judicial records and therefore they're not subject to the PRA. So they denied and in that way denied the request, and then referenced a rule that was not yet in play. I think GR 311 started several weeks after that, and all of that is correct. Yes.
Yes, Your Honor.
All right. And Judge Lanise has already ruled in a different case with a different plaintiff, I believe, that in fact the records sought in a very similar request are in fact public records.
Yes, Your Honor.
All right.
And in fact, the records given to Mr. Hupy by Lewis County on July 25th, 2017 were actually given under the Public Records Act, and those were the same documents given in the case that this court was referencing about Judge Lanise, where Lewis County was ordered to produce documents under the Public Records Act in response to the violation.
All right, go ahead.
So, in the first case, which is case number 17-2-01027-34, the court found that Mr. Hupy's complaint was time-barred that was filed in that case. Mr. Hupy filed that action in early 2017. The documents of the July 25th, 2017 production of documents had not yet been produced and were not yet alleged in the complaint. Judge Murphy in the Thurston County Superior Court ruled in a short but sweet ruling that Mr. Hupy's action was statutorily time-barred. His complaint in case number 17-2-01027-34 was statutorily time-barred. Mr. Hupy brought this action and alleged the new facts that Lewis County produced 3,682 documents to him on July 25th, 2017, which wasn't included in the original complaint.
Mr. Thomas, as it relates to Judge Murphy's order, obviously Lewis County has argued that the court should dismiss this case based on claim preclusion or res judicata. And both of you have argued what Judge Murphy's order means, and I'm looking at the plain language of the order. Her order indicates that she considered 5 different types of documents, 8 different types of documents for the purposes of her ruling on the hearing where she ultimately dismissed the claim. And those documents contain reference to the July 25, 2017, 3,700 pages that were provided to Mr. Hupy. And so those facts were considered by Judge Murphy because they're contained in that lawsuit. It says all documents contained in the file. The July 25, 2017 disclosure of 3,700 responsive documents, or potentially responsive documents that were provided, were known. Those facts were known to the court because she said she considered all of the documents in the court file when she made her decision. So I just want you to address that issue because she knew those facts. And the argument that somehow that was going to extend statute of limitations, the argument that it would extend statute of limitations, or told it. And she still said that the action was time barred. So I would like, that's what the issue I'm struggling with.
Absolutely, Your Honor, and thank you for bringing that up. Mr. Hupy's not contesting those facts, and Mr. Hupy, plaintiff, agrees with this court's interpretation of what happened in the previous case, where Judge Murphy did consider, and they were argued, the 3,682 documents were argued at the merits hearing. However, Judge Murphy's ruling is plain and clear on its face, where she didn't enter into ruling on any of that when it came to her ruling. She used restraint, and she only ruled on the facts alleged in the complaint in that case. And since those facts were not alleged in the complaint, she found that it was statutorily time barred, and she dismissed that complaint with prejudice.
And so when she used the language, the court finds it unnecessary to address any other arguments of the parties, that's what that language is referencing. She's not considering these other arguments that were made, including extending the statute of limitations potentially was told and or extended, because she was just ruling on the fact that as the case was filed, it was time barred.
Yes, Your Honor. If my memory serves correctly, Judge Murphy actually said that she looked into this issue and she couldn't find how records provided in the middle of the lawsuit would actually extend the statute of limitations. And so it was our understanding that we needed to file a new lawsuit based upon that, because legally there was nothing she could do. She was bound by the law, and it would not extend the statute of limitations for Mr. Hupy's complaint as alleged.
All right, go ahead.
So that brings us here. We alleged new facts. We alleged in the complaint that 3,682 documents were provided to Mr. Hupy on July 25th, 2017. Those facts are not in the original complaint, or the complaint from the first case, which is 17-2-01027-34. And that's a significant change. I don't think that, I haven't heard defendant argue that that is a significant change in facts. I think that that is significant when we're talking about records being withheld, and we identify Lewis County produces under the Public Records Act 3,682 documents to my client. I think that is a significant change in facts, because that talks about whether there's a violation of the Public Records Act or not.
And when they were provided to Mr. Hupy, they actually, the, I don't know, cover letter or what came with it said, this is being provided to you under the Public Records Act.
Yes, it actually says that. It says pursuant to the Public Records Act, and that's a quote. And Lewis County tries to argue with that, and they say, well, it was provided under multiple theories. But as long as it's provided under the Public Records Act, it doesn't matter if it's provided 6 ways from Sunday. As long as it's provided pursuant to the Public Records Act, at least in part. So these documents were produced pursuant to the Public Records Act. That's not in dispute in this case. And they were documents to Mr. Hupy's request. It was the email was titled with the lawsuit number 17-2-01027-34. There's no mistake that these documents were given to Mr. Hupy in response to his December 2015 request about the law library and the law library board in Lewis County. So there's no issue preclusion in this case. Mr. Hupy's arguing a silent withholding. He's arguing a failure to make a search. A failure to make a search under Washington case law is an inadequate response. An inadequate response is a violation of the Public Records Act. Alternatively, this court can look at this as a wrongful withholding. Lewis County had 3,682 documents available to it at the time, which should have produced to Mr. Hupy. It indicated that there were responsive documents to Mr. Hupy and said that he could get them under GR 31, the court rule GR 31.1, but it said that they weren't going to give them to him under the Public Records Act. So Mr. Hupy later learned that these were records under the Public Records Act. Lewis County admits that they're records under the Public Records Act when they, through their actions by providing them the records under the Public Records Act. And this is a pretty clear-cut violation. There's no issue preclusion, there's no res judicata in this case. Lewis County has the burden to prove that. They haven't proved that. In order to prove that, they need to show that there was a ruling on the merits. This court has the order. As we went through, it's pretty clear and straightforward that there is nothing in the written order indicating that the court ruled on the 3,682 documents. Lewis County tries to argue, and they say, well, the oral ruling, the court talked about the 3,682 documents. Case law is clear. It's only what's in the written order. The oral ruling can supplement the written order, but it can't overcome or it can't supplant the written order. And in this case, if Lewis County is arguing that the court ruled on it when the court said we're reserving any other issues and we're not going to rule on any other issues, that's directly irreconcilable with what the court ruled. So this court needs to look at Judge Murphy's written order, and that's all the evidence that this court needs that there is no issue or claim preclusion. Lewis County also argues that this is time barred.
Just 1 minute. Go ahead.
This issue is not time barred. The Belinsky case from the Washington State Supreme Court in 2016 is the final word so far on the statute of limitations in Public Records Act cases. And the Belinsky case clearly states that the statute of limitations starts to run from the final definitive response. Mr. Hupy was given a final definitive response on July 25th, 2017. In fact, he has not received any other response from Lewis County since July 25th, 2017. The Belinsky court goes on to explain what a response is. A response includes a production of records, according to the Belinsky court. And so Lewis County's production of documents on July 25th, 2017, under the Belinsky court's analysis, is a response to Mr. Hupy's request and is the final definitive response to Mr. Hupy's request. And the 1-year statute of limitations starts to run from that date. Mr. Hupy's lawsuit, this lawsuit was filed in December 2017, less than 1 year from the production of documents, so the statute of limitations is not an issue in this lawsuit. Mr. Hupy also argues that there was an inadequate search. Lewis County does not respond to that. Mr. Hupy also argues that Lewis County had the burden to show that its actions were in accordance with the Public Records Act pursuant to RCW 42.56.550 Section 1. Lewis County doesn't respond to that either. These are mandatory burdens that they have to prove in this case. Because Lewis County doesn't prove its mandatory burdens, it doesn't show why its withholding was within the law or how the Public Records Act authorizes that. It cannot fulfill its burden under 42.56.550 Section 1. It cannot show how it made an adequate search and how an adequate search leads to an adequate response. So Lewis County did not respond adequately to Mr. Hupy's request until July 25th, 2017. And statute of limitations is not an issue in this lawsuit, and it's not precluded under claim preclusion or issue preclusion. Thank you.
Thank you. Mr. Eisenberg?
Thank you, Your Honor. I apologize. One point that I think is useful factual background for the discussion, in case it is helpful to Your Honor, is that the records requests in the Lanise case are not in the record here, and they are not identical in one important respect. Mr. Cortland's request was for records that well predated 2010. So he asked for records during a period of time when the law report existed. Mr. Hupy's request was only for 2012 to 2015, a period in which the law library board never existed, and there was no board. So that is one material difference. When you are gauging the effect of Judge Lanise's ruling, I think it's important to know that. But on to this case. I do agree that the written order from Judge Murphy is the controlling one. Lewis County does not maintain that the oral discussion somehow overrides that order, but merely that it's useful to help understand what that order means. As you pointed out, Judge Murphy noted that she considered all of the briefing and argument, including the discussion about the effect of the July production on the statute of limitations. Mr. Hupy argued very vocally that he should get a dismissal without prejudice, because there were other facts that could be coupled with his claim that he said would allow him to rebring it. Lewis County opposed that and sought a dismissal with prejudice. And Judge Murphy, deciding that the final and definitive response was on December 15, 2015, dismissed with prejudice. So it's not the case that Lewis County is somehow forcing into that order that which is not there. This issue was before Judge Murphy. She considered it. Even Mr. Thomas's recollection of the oral argument shows that this was in the mix. It was part of the decision. And notwithstanding that argument, notwithstanding the existence of facts that maybe would allow the claim to be rebrought if Mr. Thomas was right, she decided to dismiss with prejudice. Her use of that term was designed to foreclose rebringing the lawsuit. That is why she dismissed with prejudice as opposed to without. And because that was a contested issue before her, it has meaning. And its meaning is that the claim is time barred. Mr. Hupy points quite frequently to the fact that it's the complaint that she indicates was dismissed with prejudice. But a complaint is merely the written vehicle by which a claim is asserted, or by which an issue may be brought before the court for consideration. And when she dismissed the case as time barred, she dismissed the claim as time barred. That she had considered those facts relevant to this claim, including those briefed quite thoroughly by the parties about the later production, and she nevertheless dismissed the claim with prejudice. Also, in order to decide that the final and definitive response was in December of 2015, she had to decide a factual issue. And that issue was, when was that final and definitive response? Perhaps that is a conclusion of law. I mean, it's sort of a mix, it's an application of law to fact. But she had to take the Belinsky rule and listen to the facts, including facts about the July production, and decide that that did not change when the final and definitive response was. And she decided that the final and definitive response was in December of 2015. So that issue was decided. It was fully briefed, it was before the court, and it was necessary to her decision to dismiss. So it is the type of decision that has preclusive effect. And I believe that it is directly the same as the one in this case. The reason that that is so is to hear Mr. Hupy's case on the significant change in facts he alleges. He talks about the production in July being the significant change in facts, but his claim is based on a denial and a withholding that took place earlier than that. He doesn't allege that the production of records was what was error and what causes him to be permitted to seek penalties. He claims that the letter by which we did not provide records to him in December of 2015 was the error, and that our failure to search at that time was the error. I should point out that the claim that he now brings related to the adequacy of the search is not actually alleged in the complaint in this case. The first mention of it is in the briefing for this hearing, the continued hearing. So Lewis County did not respond because that was actually not part of this case until recently. But even if it were, a claim based on an inadequate search is still one based on that December letter in which they said these are not Public Record Act records, they are GR31 records, and you need to reapply under that rule in 3 weeks. So the error on which he attempts to obtain relief, the claim itself, arose under the PRA at the time of the denial. I mean, that's sort of the moral of the Hobbes line of cases, is that the denial is what gives rise to the claim, and their articulated denial is at the time of the December 15th letter, which is well outside the statute of limitations. It was outside the statute for the first suit, and it's outside for this suit. He can't bring a claim based on the July production because he doesn't allege any error associated with that. In fact, they are glad to have received the records. It is the December non-production that was definitive and final until more than a year later he sued. That is what he uses to base relief on. It's important to note, although this court's not concerned with policy, it's concerned with the law, but the legislature chose a one-year statute of limitations as a matter of the law itself. It reflects a certain policy. The Bolensky case was resolving conflicting case law about when a two-year statute should apply and when a one-year statute should apply. And it tried to crystallize and make clearer that a one-year statute would apply. If Mr. Hupy's contention in this case is meritorious, then the consequences would be as follows. You could submit a request on day 1, and you could get a denial on day 5, for example. You could then wait 10 years and bring a lawsuit, which is time barred. But if in responding to your lawsuit, the agency said, we're sorry that you're unhappy, here as discovery and pursuant to your PRA requests are materials that might have been relevant.
Objection, it wasn't pursuant to discovery.
Overruled, this is just argument.
The idea is that you could wait an unlimited amount of time and then bring suit, and then depending upon how the agency responded to your lawsuit, including whether it decided to provide documents to you, the statute might be reanimated. That's not the intent of the PRA. It's a poor result as a matter of policy, and that policy is reflected in the Sanders case that I cite. That the Supreme Court wished to encourage agencies to provide records, because that's the point of the act. So when one sues, they wish to encourage agencies to decide which records they don't mind producing and produce them, because that is how you inform the citizenry. And to interpret that type of production to reanimate an expired statute of limitations would provide a strong disincentive to do so. It also would undermine the idea that Bolensky was trying to create a uniform statute of limitations, and not one that was so affected by the correctness or incorrectness of agencies' responses, which is what the 1-year, 2-year dichotomy had been about beforehand. Here, in some sense, the claim that the statute of limitations was reanimated is because of careless wording in that letter, that it says, pursuant to every theory under the sun, here are records, instead of just saying, pursuant to Judge Lanise's order in the other case, that says these records should have been provided, here you go. I think it undermines the policy that Bolensky was hoping to further by making a firm 1-year deadline. The final thing I'd like to point out on this issue is there's a sentence in Judge Murphy's order that says she's not considering other arguments. As in this case, you can see from the briefing that was filed, there were lots and lots of things going on in that case other than the statute of limitations. Actually, even on that topic, there was equitable tolling arguments that they had made. There were questions about whether the request came into the right person, and the argument that they were judicial records and not PRA records. Lots of very involved legal issues. And there's plenty of meaning for that sentence if it just means I'm not considering issues outside the statute of limitations. It doesn't have to mean what Mr. Hupy alleges it means, namely that she wasn't considering the late production. That reading would be inconsistent with the rest of the order, which says that she did consider the briefing and that she did decide that the final and definitive response was on December 15th and that the case was dismissed with prejudice. It is that phrase, with prejudice, that Lewis County is really reading into the fact that she must have considered this issue, because if she thought that the case was properly brought, if only the complaint alleged the later production, then it doesn't make sense for her to dismiss with prejudice and to deny him the opportunity to refile. That is, I believe, the issue on which the court should decide this case. If the court would like me to continue to discuss other issues, I would be pleased to do so, but I think that it...
So, I have a question for both counsel. Part of the ruling hinges on what Judge Murphy's ruling was from November 15, 2017, and the issue of dismissal with prejudice, the listing of all the documents that she considered, but then the sentence that says, the court finds it unnecessary to address other arguments. Language that appears clear on its face, but is argued completely differently to me from both sides. And whether or not, and I was thinking about this, and I don't like to transfer work to other people. I don't want other people transferring work to me. But it seems to me that Judge Murphy should be deciding whether or not this lawsuit is claim barred, because she knows what this language means. It would appear to be clear on its face, but it's not. If it was clear on its face, I wouldn't hear two persuasive arguments from both sides about what it means, and I wouldn't have the questions that I have, which I've asked during the course of this argument. So, as it relates to whether or not this action is barred by claim preclusion or res judicata, I mean, it appears to me that Judge Murphy should make that determination, and then if it's not, if she says it is claim precluded or res judicata, the case is dismissed. If she says no, that's not what this order means, then she could, I don't want her to have to read everything. I could give her a discrete issue to rule on. Then I could rule on the issue if the case is not barred about the allegation of the violation of the PRA, what sanctions would look like and all of that. So I'm asking that question to counsel. I've been thinking about that prior to your argument today. As I've been trying to read her order, I will tell you that while I have been contemplating this case, I read it and I felt like it definitely meant one thing, and then after a day or so, I read it again, I'm like, no, I think it means this. And so I would say the court is conflicted trying to ensure that I properly interpret Judge Murphy's order, because it does affect this, or it could affect this case. So, Mr. Eisenberg, you're having your argument right now. What about that?
Well, if Your Honor would like to have Judge Murphy consider the meaning of her own order, I think that's sensible. It is a shame because the case was originally scheduled in May and has been set over, and then it would be set over again. So I say Lewis County has no objection to that. She's in a wonderful position to know what she meant. I do think, however, that I would ask Your Honor to not take her determination as conclusive of the statute of limitations issue, just the preclusion issues, because I do argue as well that even if it's not claim or issue precluded, that it's nevertheless barred by the statute of limitations.
I'm looking at the issue of claim preclusion and res judicata, because that relates directly to the wording of Judge Murphy's order. Let me turn to Mr. Thomas with the same question, simply as it relates to having Judge Murphy interpret her own order on the issue of the claim preclusion and the res judicata.
Okay, so to answer this court's question of whether this case should be transferred back, or whether Judge Murphy, in the context of this case, should clarify the meaning of her ruling, Mr. Hupy would argue that she shouldn't. This is what courts are for, is to argue the interpretation of documents and statutes, and there's no case law off the top of my head that I know that would support the premise of bringing in another judge in order to clarify that judge's ruling. This is what this court is here to do, is in order to make legal rulings. On top of that, this court needs to consider that there's very clear case law saying that a second application for a similar proposal can be considered if there is a substantial change in circumstances or a material change in the application of the conditions of the facts of that application. It is not argued by Lewis County that there's not a substantial change in application from one complaint to the next complaint. Judge Murphy clearly says...
Okay, I'm going to stop you there. I'm going to let Mr. Eisenberg finish his argument because I just wanted that, and I wasn't indicating that I was asking Judge Murphy to clarify her ruling. I was indicating whether or not she should rule whether or not this new lawsuit is claim barred by her ruling on the identical issue in another lawsuit, but for whether or not these July 2017 facts were considered. That's the only issue, whether or not she considered that. If she did consider that and if it affected the statute of limitations, this claim's barred. That is what's not clear in, necessarily clear in the order. That's what I was referring to. But go ahead, Mr. Eisenberg, go ahead and complete your argument, please.
So I guess this will be responsive directly to the point that Mr. Thomas was making just now at the end, which is he says that Lewis County does not respond to his claim that he can bring a new complaint if it has substantially changed facts. Well, Lewis County's argument is that it doesn't have substantially changed facts because, one, he articulated these same facts in the prior case, but let's set that aside. But two, the claim that he is making is, I made a request on this day. Lewis County responded on this day with a denial. That denial was wrong. I was entitled to records. They didn't provide them to me, and they didn't do a search at that time. Then later, I learned that this was true because they provided documents to me. So his claim is still predicated on the denial from December of 2015. So the new facts that he alleges, the July production, they don't change the fact that he didn't sue until more than a year after the denial on which he predicates relief. The final and definitive action was in December of 2015. This is, I guess, another window into the same argument I made previously, which is that the date that the final and the definitive response was given, although it can be the final production of records, I mean, if you look at the text of the PRA provision that has the 1-year statute, it talks about the last production of records when you're providing an installment basis. So when Belinsky is saying that the final production of records is going to be your final and definitive response, I believe that that sentence is talking about a production in installments. I do not believe that that sentence is talking about a circumstance that we have here, where you have a clear denial because no records were produced. I think as a footnote, I should point out, in a different case, we have a question as to whether if you produce the records under GR 31.1, it counts as a denial. That's not what happened in this case. In this case, Lewis County didn't even think that the request was to Lewis County. They thought that the request was to Superior Court. And they said, we're not providing you their judicial records. Actually, to be fair, I think the record bears out that Mr. Carter perceived himself to be acting as the lawyer for the Superior Court in making this response. But it's true that the request came into the clerk, so the county was in the mix. But in any event...
You have about 2 minutes left.
Thank you. It is the case that the letter goes out and says, we're not providing you the records. Please submit this request under GR 31.1. That is the response to this request. The fact that upon lawsuit, as a result of that lawsuit, Lewis County provides more records. The second paragraph of that letter clearly indicates that it's not just that they did a search for this request and then provided those records. It is clearly about providing a full universe, it uses that phrase, of potentially responsive documents so that each side could argue what would be responsive and that the court could make the determination for penalties. So that is a lawsuit-related production. It says that it's pursuant to the PRA as well, but that, in my opinion, does not mean what Belinsky means when it's talking about definitive responses. I'm going to leave that so I can spend 1 minute on the other lurking issue, which is, yes, Judge Lanise ruled that for the requests where the Law Library Board did exist, that those were PRA records, but that request was for a broader period of time, and it was addressed to the Law Library Board. This request, Mr. Hupy admits, he did not send it to the Law Library Board. He didn't address it to them and then just deliver it to someone else. He addressed it to the clerk. He addressed it to a different agency that has nothing to do with the Law Library. He says that he gave it to the clerk because she was involved with the Law and Justice Council, a different agency under a different statute. So he delivered his request to someone else, and she didn't have any records that were related to that. So that is a fact of consequence to this case that's lurking way down deep below all this other stuff. It was articulated in the first lawsuit, and I re-raise it here. The Lewis County made all of the arguments of the Law Library Board's judicial status because it has appealed Judge Lanisa's ruling and is attempting to overturn it. That's the only reason they're made. I'm not suggesting that you would make a contrary ruling in this matter. Thank you.
Thank you. Mr. Thomas?
Let me start out with the last thing that was said, is that Lewis County says that Mr. Hupy did not address this to the Law Library Board. First of all, that wasn't argued in the merits brief. That's a new argument that's not in front of this court. Second of all, even if that was somehow argued, RCW 42.56.040 states that Lewis County must prominently display their policies and procedures. There's no evidence that Lewis County prominently displayed their policies and procedures. Mr. Hupy argued in the first case that he had no idea where to send this request to. Lewis County even admits that it was a defunct agency. So Lewis County should not be, this court should not permit Lewis County to bring up new arguments in the merits hearing. So Lewis County argues that the error is the same, and they said the error is predicated upon the denial. The error is predicated upon the July 25th production of documents, because that's when Mr. Hupy realized that they were wrongfully being withheld. Mr. Hupy didn't know that they were wrongfully being withheld. He had a feeling, and he alleged that in that lawsuit, and he couldn't prove that according to Judge Murphy. And that's why the complaint, she didn't find a violation of the Public Records Act. If Mr. Hupy could prove that the records were wrongfully withheld at that stage, as alleged in the complaint, Mr. Hupy would have been the prevailing party. So the error is not the same. I really want to go back and touch upon this court's question, because I feel like that's going to be the turning point in this hearing on whether there's another hearing or what happens. This court is at least contemplating, or at least asked both parties about whether Judge Murphy should clarify her own ruling.
I didn't use the word clarify her own ruling.
Or rule on her own ruling in the application of this case. Judge Murphy's order actually says that the parties couldn't agree upon the form of the order, and that Judge Murphy actually wrote her own order.
Correct.
This two-page document. Judge Murphy had the chance to put everything that she wanted into the order that she wanted to. She wrote the order. Judge Murphy, as argued by plaintiffs in the merits briefing, used judicial restraint, and even though there were facts and arguments argued, she did not rule on them. The ruling does not show up either factually or legally as a conclusion of law anywhere in her ruling. This court is bound by the plain language of this ruling. And in fact, we cited case law that says, Mr. Hupy cited case law in the brief that says, the plain language of the written order is controlling. And Lewis County doesn't somehow argue that it supplements the plain language or somehow it adds to the meaning there, because there is no meaning there. The court says it finds it unnecessary to address any of the arguments of the parties. If Judge Murphy wanted to address that argument, she could have put that in there. She wrote the order, but she chose not to. And so this is properly before this court. There is case law that says if there's a significant change in facts, then it is considered a new lawsuit. And in fact, Mr. Hupy points out in his amended opening brief at page 12, the definition of a substantial change in facts is when the evidence in the record is of sufficient quantity to persuade a fair-minded, rational person of the truth in the finding. Lewis County admits that they gave these documents under the Public Records Act. Lewis County admits that they gave these documents to Mr. Hupy on July 25th, 2017. That is enough to find a violation of the Public Records Act. That's enough in order to prove wrongful withholding. And so the case law is very clear that Mr. Hupy is permitted a second application of this lawsuit because of the significant change in facts. Thank you.
Thank you. This matter is before the court for the full merits hearing related to Mr. Hupy's lawsuit alleging that Lewis County has violated the Public Records Act related to his December 11, 2015 request. That was a public records request that he provided to the Lewis County clerk seeking records related to the Lewis County Law Library Board, asking from the time period of 2012, and I think it said to current, which was then, of course, December of 2015. Ultimately, the clerk forwarded that request to Superior Court, and a response was provided to Mr. Hupy on December 15, 2015 from the Civil Division of the Prosecuting Attorney's Office in Lewis County, indicating that the Law Library Board did not exist any longer and did not exist for the time period in which Mr. Hupy was seeking records. It indicated that the Superior Court itself was administering the Law Library since 2010, that any of those records, Law Library Boards from 2010 forward, since Superior Court took over, were records related to judicial administration records, and then invited a request under GR 31-1 that was actually not in effect yet, when there was the reference that that would be the appropriate way to obtain the records. On March 10, 2017, Mr. Hupy filed a lawsuit against Lewis County and Thurston County, cause number 17-2-1027-34, alleging that Lewis County had violated the PRA related to his December 11, 2015 records request. That is the same records request in which this current lawsuit is filed, relating to that same records request. While the case that I just referenced was pending, that was assigned to Judge Murphy. While that case was pending on July 25, 2017, Lewis County provided 3,682 pages of documents that related to Mr. Hupy's December 11, 2015 public records request. On November 15, 2017, Judge Murphy dismissed Mr. Hupy's lawsuit, which alleged violation of the December 11, 2015 request by Lewis County failing to produce documents. The court has the order that was entered by Judge Murphy. On December 13, 2017, this current case was filed and the litigation has proceeded from there. The first issue for the court to determine is whether or not Judge Murphy's order dismissing plaintiff's complaint with prejudice bars by either claim preclusion or res judicata the lawsuit that is currently before the court. And the new facts, I'm using that term, that's kind of how they've been referred to, which Mr. Hupy argues distinguishes this case from Judge Murphy's case, are the facts related to the July 25, 2017 disclosure of records to Lewis County. In her order dismissing, well, first of all, obviously the parties are the same in this lawsuit as they were in Judge Murphy's lawsuit. The cause of action is the same. It is a violation of the Public Records Act claim alleging violation when there was a December 11, 2015 request for records. And so the subject matter is the same as well. Judge Murphy heard argument on this case, in her case, excuse me, not on this case, in her case. And at the conclusion, the parties both submitted orders and could not come to an agreement, or if they didn't both submit orders, they certainly didn't present an agreed order. And there was argument related to the orders that were entered. Judge Murphy created her own order, and it indicates that she considered all documents contained in the court file for the purposes of that hearing. The parties agree that, and the record supports, that it was argued to Judge Murphy, the issue and the facts of the 3,682 pages provided on July 25, 2017. The fact that that somehow could impact the original statute of limitations and somehow toll it and or extend it. And she indicated that she found that the complaint, which is the claim, is statutorily barred by the statute of limitations contained in RCW 42.56.550 subsection 6. A final definitive response to the PRA request at issue was sent to the plaintiff on December 15, 2015. That clearly is ultimately her conclusion of law related to the undisputed fact that there was a response provided to Mr. Hupy on December 15, 2015. That fact was undisputed. It is the conclusion of law that that was the final definitive response. That is what gave rise to the claim that there was a violation of the Public Records Act. Judge Murphy knew when she found that the final definitive response was on that date. She knew about the later disclosed records, and she did not find that that somehow became a new deadline, or that that then became the final definitive response. She dismissed the matter not without prejudice, she dismissed it with prejudice because the complaint alleging a violation of the Public Records Act when the request was made on December 11, 2015, and the final definitive response was made on December 15, 2015, was time barred. Those are the same issues that are in front of the court, and this matter is precluded from being argued in this case by claim preclusion and res judicata, and I will dismiss the action. I would also indicate that although Judge Murphy indicates in the last line, the court finds it unnecessary to address any other arguments of the parties, there were other arguments besides statute of limitations made in the arguments that were before her on that date, and the plain language is referring to that since she ruled on the statute of limitations issue. Do the parties have an order with them today?
I have a proposal for Your Honor, and I think it's close. I don't know if you'll find it to be perfect, so I ask you to consider it.
You and Mr. Thomas can determine whether or not you believe that that is accurate, and if it is not, after you both have had an opportunity to review and discuss it, I will come back out on the bench.
Thank you.
I will be in recess. Thank you.
Thank you.
All rise.